And once again, we want to make sure you're germane in your comments on the moratorium and the administrative interpretation of the code. That's all we're talking about, not new code or anything, just the moratorium that was put in place and the administrative interpretation.
If you wish, a recorder will be summoned to take down your statement.
I have a statement to make, all right, but you can deliver it. You just tell your government that someday its own people are going to get wise to it.
I'm here today to talk about how it appears ag tourism is acceptable for some but not for others. The case in point is the Skagit County lawsuit against Mr. Larry Jensen and his business Tulip Valley Farms. For example, they are being sued for not having an event permit. According to the Washington State Right to Farm Act, their activity is allowed under state law. In fact, it's against the law for anyone to bring a nuisance lawsuit against a farmer. Yet this is exactly what Skagit County has done. Additionally, Skagit County Planning and Development Services would not sell them an event permit because they said they did not need one and no other tulip farmer has one. It clearly appears to be a targeting effort by the county. The Assistant District Attorney, Will Honey, says there were community complaints and this was a reason to initiate the lawsuit. This allegation was proven incorrect through information provided from Skagit County themselves in a video produced by researcher Jamie Crawford and a link provided to the commissioners. I think Skagit County Assistant District Attorney should be removed from office for his false claims and for targeting Mr. Jensen, Tulip Valley Farms unfairly. Skagit County should immediately drop the case against Mr. Jensen and Tulip Valley for unfairly initiating a lawsuit that targets him and his business when others are not being sued for the same things. It is my understanding that each of the commissioners has been informed of this false claim by the Assistant District Attorney, but they have done nothing to correct the injustice against Mr. Jensen and Tulip Valley. This is wrong. It's time to hold Will Honey accountable for the time, money, and damage
Thank you, Tina.
to the reputation of
Next
Mr.
is,
Jensen for actions
Larry
Will Honey
Jensen.
asked the county to take against him.
Next is Larry
Thank
Jensen.
you.
Thank you.
Larry Jensen from Mount Vernon, Washington. And I'm here today. I'm 70 years old, and I never thought that I would be here because I'm trying to sell my crop. I've been sued for growing, basically being sued for selling my crop, and I bring this up because it concerns me that the proposed process that they are putting forward is being run by the same county staff that has caused the lawsuit to be initiated against me and my business. I do basically the same thing as other tulip venues and other business owners do on their farmland, but unlike them, I've been targeted by Skagit County staff in the following ways. The Assistant District Attorney and the Commissioner said that I had requests for investigations by community members for some complaints. This was not true. There were no community complaints as discovered by researcher Jamie Crawford, but rather the complaint came from county staff. The county targeted me. The Assistant District Attorney, Will Honey, used the fake complaint to ask for a lawsuit against me, and the commissioners agreed. Lisa Janicki used the forum to say that they followed the process of first having an RFI, which is a request for investigation. The process was not followed before the lawsuit was approved, and they targeted me again. The issue in the lawsuit are common practices by my competitors who have never had a requirement or a permit citation brought against them. More proof of targeting. One specific item was a lawsuit that was demanded was I failed to have an event permit for my activities. Yet my activities are allowed under Washington State Right to Farm. Also, when my partner asked getting an event permit from the county planning department, he was told that we did not need one. Yet we are being sued for having one. More targeting. The county has continued the lawsuit.
Thank you very much, Larry.
All right, thank you. I think you get the idea. Thank you.
Respond to it both on behalf of myself and our office from those last two commenters. At the hearing where we proposed a resolution after significant discussion with code enforcement in an executive session, what I mentioned was that our code enforcement officials do not themselves initiate complaints. That is all I said. and I would sincerely appreciate if this slanderous business stopped, Mr. Jensen. This is an active litigation, and this is not the place to bring it up.
You use your 2 minutes.
Thank you.
Good afternoon, Commissioners. My name is Michaela Staples Hughes of Mount Vernon. It has become apparent this moratorium was merely a covert maneuver intended to mitigate county liability. It effectively established policy that circumvents the traditional public process that goes against the recommendations of your own appointed advisors on the Planning Commission and the Ag Advisory Board. It is imperative to express, for the record, the disappointment felt by farmers, agricultural landowners, and citizens towards our elected officials in the county attorney's office for their reluctance to enforce certain laws and their willingness to violate the GMA due to fears of negative perception. The county is now jeopardizing multi-generational family farm operations and decades of planning and development for non-compatible businesses, many of which who have operated for less than a decade. This moratorium strikes a severe blow to those of us who rely on farming to sustain our livelihoods. As is frequently stated, while we may have the right to farm, we often lack the ability due to the risks associated with farm work. With the county codifying non-compatible uses unrelated to agriculture, such as hosting wedding venue events on ag land, there arises a legitimate concern about how will it prevent other illegally operating businesses from expecting similar opportunities. Recognizing the implications of the policy established through the moratorium, I'd urge the county to consider counsel of the Ag Advisory Board when developing the VCA terms that meet the approval of farmers. I'd suggest incorporating agreement terms that necessitate venues to be accessory to a working farm, mandating an annual compliance review, ensuring the operation does not exceed the GMA's 1 acre allowance for non-agricultural accessory use, and limiting the events to 24 or less per year. Commissioners, you now have the opportunity to rectify a grave mistake by ensuring consistent agreement terms within the VCAs. Please reaffirm your support for the county's farmers. Thank you.
Regard along Mount Vernon, Commissioner, I really want to emphasize not so much the goal you had in the moratorium that you passed, which seems to be clearly a moratorium on additional requests for bed and breakfast or perhaps wedding venues. But the interpretation by your staff is quite contrary to that. It's not just a moratorium on new applications. It's an attempt to control all existing accessory ag uses, not just wedding venues. If you look at the language in what has been written, there is no limitation. It simply requires all existing accessory agricultural uses to self-report. So if you've got a flower stand at the end of your driveway, you have to self-report it. Once you have self-reported that flower stand, you have given the county all the information about your operation, good or bad or indifferent or in violation or not in violation. In return for self-reporting yourself, the county says that they'll come and regulate you some more. That's the result. So you are being told you have to turn yourself in. Now the county will tell you we only have 2 code enforcement officers. Well, if you have to turn yourself in, they don't need just 2, do they? And then you're given the choice. Either you turn yourself in or you lose your existing accessory use. If you do turn yourself in, then you have to comply with whatever staff comes and tells you, so your flower stand at the end of the driveway may not have a sufficient area for people to pull off and buy your flowers or whatever it is, or maybe the drainage is wrong, or you need the APA out there. It is an attempt by staff to grab tremendous power over all existing accessory uses. You can limit this first by limiting it to the subject of the moratorium. Thank you.
Thank you, girl.
My own countryman once said, you can't fool all of the people all of the time. Believe me, you communists can't keep fooling the entire world. You can't even keep fooling your own people. Because the news about communism is getting around. That it's only another word for slavery.